Hello, everyone, and thank you for joining the Annuity and Life Source and Chip Anderson from NAFA. We know your time is valuable, and we anticipate that this webinar will take approximately 45 minutes. While time will not be allotted for questions at the end of Chip's presentation, you can talk with our office Monday through Friday by calling or sending us an email. If you have questions following the webinar or would like to know how to partner with the Annuity Source so that we can support your business, I will share our contact information towards the end of the session. And I don't think I've introduced myself. I'm Margot Thompson, the principal of the Annuity Source, and we're happy to have you here with us. I'm just going to take a few minutes to introduce Chip Anderson. Chip asked me to keep it very very small introduction so that we could spend most of the time on the NAFA information. But just a little bit about him, he has spent 35 years of sales and senior management experience in the annuity and life insurance industry. And Chip is committed to helping organizations, annuity professionals, consumers, all maximize the value of annuities as safe money products in the marketplace. And I asked Chip to join us this afternoon. This is actually the very first webinar after the first lawsuit has been heard in D.C. And he has just recently come from that hearing. And it is just the first of 5 important lawsuits that argue the rule. And so we're going to have the first thoughts that Chip has to share with us today, talking about that and where he sees things going from here on out. So with that, I'm honored to hand the floor over to my friend Chip Anderson.
Margot, thank you very, very much, and thank you for allowing me to talk to your group here today on the webcast. I did just get back from the hearing last week on Thursday in Washington, D.C., and we have a lot of information to share. I'm going to go through just a quick little background and spend most of the time toward the end in regards to the hearing and basically what that means to our industry. But I think it's important for those that are on this call, this webcast, to understand what has led up to this a little bit. So we'll jump into that. Next, please, Peggy. Here's a disclaimer out there. It just says anything that I say basically won't hold against me. If I happen to make some comment about the current administration that you might not agree with, you won't hold that against me. But basically, this is our disclaimer. So thank you. Next. Let's look at kind of where we've been. And I think it's important for you all to know that NAFA is not just working on the lawsuit, but we had a meeting in D.C. on June the 8th and the 9th where 125 of the NAFA members attended our 2-day meeting so that we could meet with our senators and congressmen. We did a hill walk, and we had 253 separate appointments with members of the House and Senate to work on the legislation side of this fight for our industry against the Department of Labor. We made our presentations. We had face-to-face conversations with senators and congressmen and their staff. We had a really good showing, and this was the largest meeting that NAFA has had over the years in D.C. at this time. We have that meeting on a regular basis. We encourage all of you who are out there, if you haven't been to D.C. to attend this meeting, to do so. This is a great opportunity for you to get your point across to your representatives in D.C., but also a great sales opportunity for you to tell your clients you went to D.C., you went to Washington to fight on their behalf and to make sure that the products that you're marketing, whether it's life insurance or fixed annuity products or whatever they might be, that these products are out there and available for you, your clients. I think that's a real key thing. If you haven't ever been to D.C. before, this meeting is a great opportunity for you to come and present at that meeting your views to your representatives. We had a panel presentation in regards to the DOL ruling to update everybody. And then we also had speakers from the Hill, Congressman Phil Rowe, Congressman Blaine Lukemeyer, Senator Johnny Isakson, and then our keynote speaker was Jeff Bush, no relation to the Bush family that has been in the White House, but he is very good and gave us a Washington update in regards to the political scene and certainly what the new people coming in as far as the election might mean for us. So great information for you. There's some pictures of some of the people that were there and some of the presentations. Next. Let's jump right into the DOL Fiduciary rule. NAFA filed our lawsuit on June the 2nd, and as Margot mentioned, There's a number of other cases that have been filed in regards to lawsuits from some other organizations, and we'll touch on those in just a few minutes. But basically, there were 6 claims that we had for our lawsuit. The DOL exceeded its legal authority in expanding the definition of fiduciary to include insurance agents who sell fixed annuity contracts. This goes back to ERISA guidelines, the Employment Retirement Income Security Act, just to remind you all what ERISA stood for. ERISA guidelines in regards to qualified plans and the fiduciary guidelines within those plans. That came out in 1975, and it's worked very well on qualified plans, and there are specific reasons and guidelines why the fiduciary duties are assigned to qualified plans. I would remind everybody that this DOL ruling just applies to qualified money as far as the Department of Labor is concerned. But quite frankly, as we go forward with this, there'll probably just be one standard to judge sales and suitability and guidelines compliance from the carriers, from the broker-dealers, from a lot of the people in our industry. I predict, this is me personally, but we've had conversations on this, you can't have 2 standards. You can't have a standard for qualified money, which is what the DOL rule is talking about, and a standard for non-qualified money in regards to the sales process. So in all likelihood, in my opinion, the DOL rule will cause the broker-dealers, the insurance companies, and everybody to have one uniform guideline in regards to sales, whether it's qualified or non-qualified money. The DOL doesn't really care about non-qualified money at this point in time because they don't have authority over the non-qualified sales. They just have authority over qualified plans, pension plans, profit-sharing plans, 401ks, etc. We think the DOL exceeded the legal authority to impose the ERISA fiduciary standards regarding IRA transactions. Now, keep in mind, this is a little of the background, but it's really important to understand this from your perspective. DOL is regulating qualified plans, as I mentioned, 401ks, pension plans, etc. In that, the fiduciary who manages those plans really is the one who controls all the products, all the guidelines, everything in that plan, and an employee under a pension or a profit sharing or a 401k plan doesn't have really any way to get out of that plan unless they leave the employment and get out of there. So there is a reason for fiduciary guidelines there in regards to the management of the plan, the bringing good products into that plan on the qualified plans, and making sure that the people involved in that plan are well represented as far as the management / the fiduciary of that plan. And there's strong guidelines for the fiduciary there. Now, individual IRAs are not part of that until now, which the DOL wants to sweep everything in there in regards to IRAs and individual accounts. Well, as you all know, IRA stands for Individual Retirement Account. And I'll pose the question to you, but I'll answer it. Who is responsible for their own IRA? That would be the individual. The individual, if they don't like the mutual fund they're in for their IRA, they can move to a CD. If they don't like the CD that they're in for their IRA, they can move to a fixed annuity product or a fixed indexed annuity. They have control over that. In a qualified plan, while they can make some changes within that plan in regards to different mutual funds possibly or whatever, they really don't have control over that. An individual retirement account, they do have control. But the DOL has said, we want now to all those people to have fiduciary guidelines and have the same standards of a management of a qualified plan for IRA transactions also. And all the liability, not just the responsibility, but all the liability for IRAs. IRAs are for individuals, and they make those decisions. They choose which product they want for their IRA, not necessarily the salesperson who the DOL wants to be the fiduciary. Third point, the DOL exceeded its legal authority in creating what's called a private cause of action, private right of action under BICE. Only Congress can do that. What this does is open it up for legal action. If a person thinks that they were sold the wrong product, if a person thinks that maybe the commissions were too high, then they have the ability to sue the salesperson, the insurance company, the broker-dealer, or whatever. prior to this, that hasn't been in play in regards to the sales of fixed annuity products. This is a difference which is really going to be a deal breaker as far as the industry is concerned, as far as broker-dealers are concerned. It opens up litigation to the entire industry, and the clients can go out and get an attorney. The attorneys can put together maybe, a class action lawsuit that could cause a tremendous financial liability to the entire insurance industry and the financial services industry in general. DOL, in creating this, has opened the door for what's called private right of action in regards to people suing their financial advisor for what they might deem as an incorrect sale to them. Next page. Continued in regards to the 6 points that NAFA has, the definition of reasonable compensation, which the Department of Labor, the DOL, is trying to tell us everything has to have reasonable compensation, yet they will not say what reasonable compensation is. And that is so vague that it actually violates a part of the Constitution called due process clause, which they have to have some kind of a definition rather than just saying, well, we think that compensation was unreasonable for that product, so you're liable and you can be sued, which is actually what they've done. Next, the last-minute switch to put fixed indexed annuities under BICE and to treat fixed indexed annuities as securities is contrary to law and we think is totally unworkable. When the original Department of Labor proposal came out in 2015, April of 2015, fixed indexed annuities were under a clause called 8424. They were separated. They didn't have to go under the guidelines that the DOL has put forth. Now, as a last-minute change, this year, when the final rule came out in 2016, April of 2016, they had moved fixed indexed annuities from the 8424 guidelines under BICE, and totally different classification, and all the rules and regulations apply to fixed indexed annuities. This was a last-minute switch, and we think that they misconstrued the products and misunderstood them and shouldn't have put them in with the securities products. Very important. And as a note, when the original rule came out in April of 2015, that proposed rule from the DOL was 250 pages. They clarified everything, made things a little simpler, a little tongue-in-cheek there, and the rule that came out in 2016 was over 1,000 pages. 1,000 pages to define what a fiduciary is and what best interest of the client is and what they think reasonable compensation is, although they didn't give us clear guidelines on the reasonable comp issue. Last but not least, we think that the Department of Labor failed to conduct an adequate business impact analysis, which is required under the Regulatory Flexibility Act. They really didn't do anything. Any numbers that they used were numbers based on more the financial services industry as far as the securities industry with mutual funds. They even went forth in their last proposed rule where they said the losses that clients are having, is tremendous in regards to the products that are out there. And they inferred that those were fixed indexed annuity products. Yet later in their rule, they came back and made it a little clearer that the losses that they were saying that people were having on sales charges and on administrative fees and commissions, that those losses were actually losses of a bad market, of losses in underperforming mutual funds in a bad market. And these were billions of dollars that they claim that clients are losing money. But then they clarified it about 20 pages later, that their reference was really to underperforming mutual funds in the market. In our briefs back to the judge and the DOL, we made notes of that and made it clear that they basically misrepresented what they were saying. So those are the 6 key points that we, back in June and July, got back to the judge on in regards to where we think the Department of Labor made their mistakes in regards to putting fixed indexed annuities in with securities, in regards to their overreach, in regards to their guidelines, and that they were trying to do things they couldn't do. Now, let's move forward until last Thursday, NAFA versus the Department of Labor. We had greatly anticipated this. There was a lot of time and effort that went back and forth. A lot of the other groups out there who are working on these things certainly have been working on their hearings also. But we had the hearing, which was at 2 o'clock last Thursday afternoon. And as Margot said, you all were the first to kind of get this report directly from NAFA. Phil Bartz with Brian Cave Law Firm represented NAFA. A number of people were there from the NAFA organization. We had some of our board members there, Eric Marhoon with F&G, Chris Conroy, and who's the head of our litigation committee, Pam Heinrich, who is the NAFA legal representative that we have, who's our chief legal person. And then certainly we hired Brian Cave Law Firm, which is a large law firm in D.C., which has experience with 151A when we fought that battle about 8 years ago now. And Phil Bartz is the lead counsel with Brian Cave, who represented NAFA. Then the Department of Justice, interestingly enough, the Department of Justice, a separate government organization, represented the Department of Labor because the Department of Labor doesn't represent itself in court. Interesting key point in that. There were 2 attorneys from the Department of Justice that were there that represented the Department of Labor. There were over 100 people in the courtroom. It was standing room only. We were a little surprised by that. We had arrived the day before because we had meetings with other trade groups to kind of coordinate and work on things with them. But we arrived at the courtroom at 12 o'clock, 2 hours early, and there were people there already waiting to get into the courtroom. The judge had locked the doors because they didn't open the courtroom until about 1:30, but there were people standing in line to wait to get in there. Who were those other people, you might ask? Well, those were attorneys from the other organizations that are also filing suit against the Department of Labor. Those were also people from the press. Those were people from other trade groups in the financial services industry that certainly are represented with the Department of Labor issue, as NAFA is not the only one that has a concern with this. And a number of interested parties were there. There were attorneys from ACLI and a lot of the other trade groups who told us that they were going to be there. As Margot mentioned, NAFA's case was the first one against the DOL, and there's a number of other cases by other organizations that will be heard over the next few months, and I'll touch base and get a little more involved in those in a second. Next. Here were the main points that we were able to present. We, in our briefs, in our legal briefs, and a lot of the information that we shared with the judge, who also shares that with the Department of Labor as we get information from the Department of Labor too through the judge. There were main points that we presented at the hearing. With those main points, the first one was the basic premise that the Department of Labor exceeded its authority within the ERISA guidelines. As I said earlier, ERISA has been around for 40 years. There have been very few complaints on fixed indexed annuities in the marketplace and fixed annuities per se compared to other products, security products and variable annuities that are out there. We don't think the Department of Labor has the authority to do this, and certainly, as I said, only Congress can make some of these changes. The Department of Labor disagreed with that, and certainly they had their time to make their presentation. Our presentation actually was first to the judge. Phil Bartz got to go first and state our case in regards to how we felt, and then there was a break, and then the Department of Labor had 2 attorneys there. They split it up, and they actually got to present their case afterwards, and after that there were different key points that we got to argue at the end in regards to contradicting some of the things that the Department of Labor said. Number 2, this is the real concern here that's created what's called a private right of action, causing a tremendous financial liability for the industry in our opinion. Keep in mind, from the security standpoint in regards to the client's money, the insurance companies and financial institutions who work with the agents and the registered reps for the client's money are the ones who are investing that money. If there becomes a lawsuit where there's a class action suit and an insurance carrier, let's just take an example where there's a class action lawsuit, and an insurance carrier might have to rescind, refund 2 or 3, pick a number, 2 or 3 or 4,000 annuity policies in a class action suit, that would have a financial impact on that insurance company. And then as other carriers might get sued, this is a hypothetical situation, but certainly one that could come into play with what the Department of Labor has created. As other insurance carriers might get sued and have to rescind policies and give that money back, and damages maybe to clients if they lose a case in regards to the products that were sold or commissions that were paid or whatever that might be. And keep in mind, the Department of Labor actions open all this up. We think that creates a tremendous financial liability for the insurance carriers. It's kind of like a house of cards, or you know, that collapsing. You know, one goes, then another one gets sued, and that goes, and that goes, and that goes. And it doesn't take very much for this to create a financial hardship on the industry. And it doesn't just affect those people that might bring a class action lawsuit. It affects all the other policyholders that have had policies with that insurance company for years, because if the policies have to be rescinded, given back, and if there's a lawsuit and there's damages, you know, all those losses add up for the insurance carrier, and they can't meet maybe some of their obligations. Well, that's the story that we presented to the judge, and certainly the Department of Labor disagreed with that. We think that this financial liability that the Department of Labor presents is unprecedented. Those are words that were used, and unworkable, and certainly something that the industry has never seen. We do think that there are some people that are out there that don't realize the financial implications that the Department of Labor is presenting with allowing a private right of action. When NAFA met 1 year ago in July, a month ago, a year ago, we met with the Department of Labor in D.C. to try to work through some of these issues. I asked specifically to the people, the head people at the Department of Labor, how are you going to regulate your rules? How are you going to implement these guidelines that you're trying to put in place? Do you have the ability, do you have the people, do you have the knowledge to see what's right and what's wrong, and to make sure that you're regulating the rule you're putting in place? And the Department of Labor said to us, the NAFA group that was there, we have no plans to regulate this. We're going to leave regulation up to the clients and the clients' attorneys in court. So clearly, they are creating the private right of action. And in their statements to us, to NAFA, they basically told us that. Next, we think IRAs under the ERISA guidelines. No, I'm sorry. Go back to that page if you would, Peggy. My apologies. Number 3, including IRAs under the ERISA fiduciary guidelines is beyond the Department of Labor authority. We talked about a little bit that IRAs were never meant to be included in regards to the ERISA fiduciary guidelines. IRAs are controlled by the individual, hence the name individual retirement account. They determine what product they want for their own IRA. They can buy their IRA, go to a bank and buy a CD. They can buy a mutual fund. They can work with an agent or registered rep. But if they're not happy with the product in their IRA, they can certainly make that change the next day if they want to, unlike being in a qualified plan of work where they really can't get out of that plan unless they leave the employment of that company or do some other drastic action to get out. Number 4 on that, moving fixed indexed annuities in the hearing was a big consideration for us under BICE, and that was a last-minute change, and they decided to include fixed indexed annuities in BICE and not under the previously 8424 guidelines that we were under, which didn't include us in the fiduciary role and the BICE. This is all very important in regards to making our case, and certainly we think the product is the right product many times for clients who are looking for no downside risk and a guaranteed income. But I want you all on the call to keep in mind this isn't really always about the product as far as the judge and the Department of Labor is concerned. For the judge, this is about, does the Department of Labor have the authority to do what they're trying to do? And even though he has to have a fair understanding of the product, it really is more about the legal aspects and what's called the administrative, the APA, you might hear that term. APA stands for Administrative Procedures Act, and that's the ability of the Department of Labor to do what they're doing, to create some of these new guidelines and new laws where we don't think that they do, and they think, the Department of Labor thinks that they have that right and that ability to do it. So all those things come into play, and while looking at it on the surface from the viewpoint of an individual agent or registered rep or an insurance carrier or a marketing organization like Margot's organization, we know how good these products are and how they help people. But from the judge's viewpoint and from the Department of Labor, they're just looking at it, did the DOL have the authority to make these changes and do what they wanted to do? It doesn't matter if the product's the greatest product in the world, you know, does the DOL have the authority to step into this and make these changes for our industry? All these things, we did a good job in regards to presenting our case. The judge understood that. The Department of Labor had their viewpoint in regards to that. And to be frank, they don't understand our industry quite as well, but they really didn't have to. They're just saying from a government point of view, and all of you have witnessed that, certainly over the years, the government can basically do what they want to do. A great example is, you know, the healthcare industry the last few years. And for those of you that didn't see this, this is just a little side point. For those of you that didn't see this a week and a half ago, there's information out on Obamacare that there are average increases across the country coming out for next year of 20%, with some states that have this in place, maybe as much as 38 to 40% increases. Well, I thought that the government told us that that was going to get the cost down on health care for everybody. And many of these people, there aren't nearly as many people signed up for Obamacare as there were, 10 or 11 million, where there were supposed to be 21 million. And certainly a lot of these things are coming into play where the industry, the healthcare industry, said, this is not going to work the way that you thought it would. Since there are only 10 or 11 million signed up, as you might expect, those people that are signed up are really the ones that are not the healthy people. So the cost incurred is increasing dramatically because the healthy people are signing up for health care outside of the Obamacare plan. And so this is creating real issues with the concept that they put together. Well, while you might ask why I mentioned that, I think that's a great example of the government stepping in to an industry that was run on the private side as far as the healthcare. Were there some issues on the healthcare side that we need to correct? Certainly. But they're making it even worse. You know, think if you had to face a 20 to 30, 40% increase on your healthcare cost, that would be almost insurmountable. Well, we think that's a great look at what they're trying to do in regards to the government stepping into these issues on the financial services business with the Department of Labor and trying to control things, and then just saying, well, if you don't like it, you can sue the insurance company and you can sue your agent or financial planner and you can get relief that way. Well, that's really not the way that it should work. I mean, why should somebody have to sue them when there's great things set in place by the individual states in regards to suitability and compliance with what we've reviewed, very few complaints over the last few years on fixed indexed annuities and fixed annuity products. So those are the challenges that we have. After the hearing, after the judge heard everything, it was about a 3-hour and 15-minute hearing with a lot of questions and things going back and forth from the judges and from our law firm, Brian Cave, and from the Department of Labor. And at the end, the judge said, I've got a lot of information here to review. I've got a lot that I have to consider, and I will basically review what you all said and get back with you in a few weeks. Now, he's very vague on that. We think it might be 2 to 3 weeks, maybe even 30 days. So that's where we stand after the hearing. We would have loved to have had the judge say, well, you know what? I understand everything, and here's my decision. But the judge is being very good. We think he's a very smart judge. Judge is being very good in making sure that he reviews everything to understand the implications on what he has. So that finished our hearing, and then we wrapped everything up. And as I mentioned to Margot, you guys are some of the first to hear the details from the hearing. Next. Additional suits that were filed. And June the 1st, the day before NAFA filed, the U.S. Chamber of Commerce and others, there's about 8 other groups beside the U.S. Chamber, they filed in the U.S. District Court in Texas. In conjunction with that case in Texas, the American Council of Life Insurance, ACLI, on June the 8th, along with the Indexed Annuity Leadership Council, also filed in the state of Texas. Those 3 suits have been combined to be heard by the same judge, and that hearing will be in November, November 17th, which is a couple of months, certainly 2.5 months away from now. Also, there was another suit that was filed on June the 8th, but in Kansas, in the state of Kansas, by Market Synergy Group, a group made up, and their headquarters are in Kansas, and that is going to be heard next month, September 21st, in Kansas City, Kansas. The judge moved that from Topeka to Kansas City, Kansas, to make it easier on the people that were traveling for that. So there are 2 additional lawsuits. Those three groups were combined into 1 suit, so there's 2 additional suits that will be heard. There is a possibility that we might have some answer back from the judge prior to the Market Synergy Group lawsuit, which is September 21st, but we can't count on that. Certainly these other judges that are hearing these other lawsuits have different things that they're going to be looking for, but all of these suits really affect the others, and we just hope that there's some consideration for the information that we shared with the judge in D.C. that would benefit these other groups. Next. Okay, this is information that's at the NAFA website and information that you can go to and download, and there's packets there, and you can help by reaching out to your elected officials in regards to sharing information with them. Your voice makes a big difference with your senators and congressmen and the people that you can reach out and talk to. The fact that you're in their district, they will listen to you. And there's plenty of materials here that you can go to the NAFA website to get a little background in regards to what NAFA's position is on the DOL issue and how you can be better equipped to maybe send a letter or pick up the phone and call them, or actually go meet them in person if they're still at home in your district as they're on break now from D.C., and talk to them and give them your viewpoint in regards to how the DOL rule will affect your business in particular, that it might put you out of business, that it certainly would create problems for you. You're going to have to be very careful in regards to lawsuits that you could incur in regards to clients being unhappy with the products or whatever it might be. Next. Next thing. Yeah, what can you do to help? You can contribute to the NAFA litigation fund to help defray the legal battle. As you might expect, for this 1.5 years that we've been working on this, our legal bills have added up tremendously. We've had a lot of support, and I will mention Margot and her organization have supported us financially in this on your behalf, but we need everybody's help. Even small donations make a difference, $100, $200 from individual agents and registered reps. Be part of the solution. Help us, help NAFA in our legal battle. These expenses are tremendous, and we're not done yet. There'll be an appeal. If we certainly don't like what the judge says, we'll have to appeal, which takes one other step in the legal process. So contribute to the NAFA litigation fund. You can go to the NAFA website to do that. Number 2, stay up to date as you're doing right now and support NAFA's efforts to fight the DOL rule. Thank you for dialing in and listening to this to get an update that shows that you're interested in what's happening with the DOL rule. Complete our virtual hill walk, as that slide that was before this, by contacting your elected officials in D.C. or in their state offices, and then contribute to the conversation. We want to hear from you. Call and talk with the people of Margot's organization and let them know what your feelings are on that. Ask questions, get involved. It's really important to do that and make your voice heard. I know that this might be some of the first time that you guys have heard a lot of this information, but it's important for you all to get involved, contact your representative in D.C. or at the state level, and also contribute to NAFA. We need your help. You all can be part of the solution, and the battle is not over. It's just beginning with the hearing that we had last Thursday. So we're going to need a lot of help as we go forward, and we certainly appreciate Margot and her organization and the support that they've given us, because they are really working on your behalf to make sure that NAFA succeeds in this endeavor. Renew your membership for NAFA going forward in next year, and Joe Greco is Director of Membership, and you can reach him at joe@nafa.com. If you're not a member, please join. If you are a member, make sure you renew for next year. We need your financial support, and we need your involvement to make sure that not just this issue, but other issues that we have come up going down the road, that NAFA is there to fight on your behalf. We're your advocate. We're your one that supports, as far as an organization, the sale of fixed annuities in the marketplace. So keep that in mind. I'm going to turn it back over to Margot. We thank you very much, and questions you can certainly direct to her organization, and we'll be glad to try and help Margot with anything that she has coming up in the future. So thank you very much, Margot, for the opportunity, and we really appreciate your support.
Thank you so much, Chip, for being with us today and for obviously your hard work on our behalf. Your feedback is invaluable to all of us as we are working to try and understand the DOL rule and what it means to us and our industry and our practices. So the most important thing that I heard today is that NAFA is completely and totally committed to helping us thrive in this post-DOL world, if you will. And I'm sure lots of you on the call have questions, and unfortunately, just with the amount of time spent going over the details, we weren't able to take the live questions. But we are able to take those questions, answer a lot of them, and check in with Chip and some other folks to get information if we aren't able to answer those questions. One thing I do want to note is that Chip has made an invitation today to join NAFA for a discounted $99 rate to sign up. And honestly, this is the most important time to join NAFA. This is our fight, and it's a fight for our livelihood and the risk to our organization. So you need to support the organization that is on your side, and that is NAFA. So thanks again, Chip and NAFA, for the call today. We really appreciate all the information you've shared with us, and we look forward to hearing more from you. So please feel free to get in touch with us, our office. Here's our information, and we in turn will be reaching out to everyone else. So thanks so much.